Hi, this is Curt Barone, and welcome to another edition of Fire Law Roundup. Again, another case. Next one, there's a couple of issues I want to kind of bounce off you here, but this is out of Connecticut. We have a Bridgeport firefighter who was terminated in 2017 for acting, and the quote here is bizarre, but the court also refers to it as strange, unusual, and bizarre. But he was terminated for that. And as it turns out, it appears that he had been terminated in 2012 for similar allegations. And in Connecticut, they like here in Rhode Island, under collective bargaining, we would appeal to a AAA arbitrator through collective bargaining. In Connecticut, it goes to a state sort of run panel of 3 arbitrators. And so he appealed, or he grieved his termination in 2012. The appellate arbitration panel ordered him reinstated, but said, termination was too much for what he was accused of, but we'll give him a 30-day suspension without pay. So he's back on the job, but he was basically on notice that you can't be acting, quote unquote, bizarre. Okay. So now he does it again in 2017, and this time he gets terminated. They grieved it. And a couple of points here with the grievance arbitration decision. I thought they did a really good job of explaining just cause. There's a lot of misinformation, misunderstanding about just cause. And they did a good job of explaining, in the 7 different parts, the 7 different aspects that should be considered in a just cause ruling. But at any rate, he wasn't satisfied with that. So then he and the union appealed that to Superior Court. So what we're dealing with here is the Superior Court's decision that upholds the arbitration decision. And one of the issues was apparently his captain. In the 2017 incident, his captain videotaped him. Oh, video, here we go. I'm dating myself by saying tape, but video recorded him, right? Hey, Dad, what do you mean tape? But video recorded him on a cell phone. And apparently he's alleging that, number one, that violates the department policy, which many departments have a policy that prohibits recording in the workplace, but also violated state law. And Connecticut is one of those states that you've got to have all-party consent to record. Right. But the court kind of brushed over that and said, no, for this purpose, that was a legitimate recording. There was no rule violation. The chief had testified that it was okay, and they upheld the termination. So what do you think about that, though? Like, in those states, I think New York is one of the states, right? You're an all-party state for recording.
We're a one-party state.
One-party state. That's, yeah. And I think there's 36 states that are one-party. So there's some like 13 or 14 that are all-party states. Go ahead.
We really don't get much of a mental picture, so to speak, as to what was going on here when I say bizarre behavior.
Right.
Was he doing backflips across the apparatus bay, and everybody was there videoing him, and he clearly knew he was being recorded? We don't know.
Yeah, one of the things I discuss in my discipline class, and I emphasize the same thing, and you're gonna pick up on it immediately with your police background, is the difference between facts and conclusions. And bizarre behavior is a conclusion, right? Spell it out factually. What was it that led you to the conclusion that the behavior was bizarre? And we don't see any discussion of the facts.
There's a lot here that's not being disclosed to us, but clearly they crossed their T's and dotted their I's, or they would not have achieved this result. And I thought that from an administrative point of view, from the agency's point of view, that they really did a good job of following their policies and procedures here.
Yeah, and I agree. And what we're dealing like with two steps removed, because we're dealing with not the facts of what happened, but we're dealing with what the arbitrator said. But we're not even dealing with what the arbitrator said. We're dealing with what the court said the arbitrator said.
Right.
So we're a little bit removed from the factual point, and we got to assume that there are facts that substantiate this. One of the things I thought was troubling here is when he had the opportunity at various points to explain his behavior, he didn't.
He didn't, exactly.
You know,
Very strange.
And you know, you would think that if maybe he was having some sort of you know, family problems, or you know, chemical imbalance, or whatever it may be, that he would have said, I'm sorry, I shouldn't have done it. This is what caused me to do it, and I'm sorry. He didn't do that. He just, like,
I also didn't see anything in here where he availed himself or tried to avail himself of any sort of employee assistance program.
Yeah. Yeah. And that may well have been, he might have, but it didn't get in here.
know.
But again, the you know, I agree with you. It looks like the city did a good job. Couple of takeaways from this one, or one big takeaway is folks who are concerned or maybe a little bit confused about what is just cause. Both the panel, the arbitration panel, and then the court did a good job of explaining those 7 things. I've got them in bold print. You can see them right there. But those are 7 commonly considered issues to be dealt with regard to just cause. There is no single definition of just cause, and generally it's up to each employer to come up with their own definition of it, unless it's been defined either in statute or maybe a city charter or something, collective bargaining agreement. But pretty comprehensive explanation of just cause there.
Well, you know, just cause really in layman's terms is a reason. And
right.
Those are your 7 steps to arrive at a good solid reason. And I think, you know, what's spelled out there is really a good primer for anybody who is just starting to become involved, perhaps in a union, as a union rep or whatnot, that those are the things you really need to look at in a situation. I mean, you can check off the boxes there. And again, from the administration's point of view, it really underscores to me the importance of training, especially because when you look here at point number 2, you know, being fair notice. Well, that gentleman clearly had fair notice with a 30-day rip. But, you know, if you start at the beginning of a career, what are the folks in training telling you, and how much are you learning along the way? You know, at what point were you distinctly told, and at what point does it become, well, you know, you've been here long enough, you should have known. You know, so it really, to me, and I was an instructor in the police department, which I absolutely loved that job. And as we all know, if you didn't write it down, it didn't happen.
Yeah.
And, you know, in so much of this litigation, it's who taught you, what qualified him to teach you, et cetera, et cetera. You know, do you have your good attendance lists? Do you have your quizzes and whatnot to show that learning occurred? Or is it just, you know, okay, here, this is how you this is how you use a set of irons, you know, hit the Halligan with the sledgehammer. You're now fully qualified in the use of this tool. You know, is that going to fly in a courtroom?
Well, and I do want folks to know that you are also a firefighter. Okay, you have background as a police officer, but your heart is in the fire service.
I'm an adrenaline junkie. I can't get enough.
Okay.